Hey patent friends, Dylan here. So I'm giving a talk at my firm's Tech Equity Hub IP session, and the Tech Equity Hub is an incubator for female, Black, and Latinx tech startups. And so I'm going to be talking about patents in this. So I wanted to give you a recording of my practice session that I'm doing for myself for my little section on patents. So stick around, we are starting right now. So let's start off with what the basics of patents are. So a patent gives you the right to exclude others from making, using, selling, offering to sell, or importing the claimed invention into the country. So for a United States patent, that would be within the United States. What's important to understand about this is it's a negative right. That being that it doesn't give you a right to actually do somebody, it gives you a right to exclude other people from doing those things. A good example of this is, say, in pharmaceuticals, where you could get a patent on, say, a compound for treating cancer, or you could get a patent on a method of treating cancer with that compound. But that doesn't give you a right to actually treat people with that compound using that or the method. So you would actually have to go to the FDA, and the FDA would have to give you approval. The patent, again, it would allow you to exclude others from doing that, but it doesn't actually give you the right to do that yourself. Okay, so that's sort of the basic monopoly of patents, and that's what people usually think of. And you think that that's the most important thing, but especially for startups and early stage companies, that's probably the least important thing that you're going to be doing with patents. You're probably not going to have the money and the ability to stop people from doing things. That's really expensive to do. So what is really important? Well, it's things like, for instance, licensing. So whether you have a pending application or an issued patent, you can license that to other folks. And a license is where you hold on the rights, and you can either exclusively or non-exclusively, that would be to multiple parties, you can give them a license, and that could be, say, for a lump sum payment, or it could be for royalties, or really any sort of consideration. Another option is that you can sell patents. So patents have an intrinsic value, and so instead of holding on to the rights yourself, you could sell that to another company. Also, it creates book value in the company, which can be used in a couple of ways. One is for valuation in terms of investors. So investors are going to look at your patent portfolio, and that's going to be part of your assets that you have for your company. Having a patent portfolio is definitely going to increase your valuation. Also, a sort of a book value that can be used as collateral for loans. But those things are in some ways are also not as important in early stages. In the early stages of tech companies, the most important things are going to be the soft benefits of patents and IP. One of them being sort of the marketing purposes. So having a patent portfolio, pending applications, issued patents, that makes you stand out to potential customers, to potential business partners, and most importantly, to potential investors. Those are the things that are going to really get you traction with those folks. So it can give you sort of positive marketing benefits and optics when it comes to those sort of folks. So on the other side of that is it instills fear in competitors. So if you say you're patent pending or you have patented technology, a lot of times people don't know what's patented and what's not. And they're going to be kind of scared off in a lot of ways. And you can use this to your benefit regardless of whether your patent application is pending or whether it's issued or not. You really a lot of times can't quantify how much benefit this is, because you don't know of the people you've actually scared off. But there tends to be a lot of benefit. I see this on the other side where people, if they weren't to work with me, or people who after the fact have said, oh, well, I took a license, or I was afraid to get into this market, they don't really know what's patented and what's not when it comes to issued patents or even pending applications. Along with that is you get the benefit of a published patent application or an issued patent. And this gives you a benefit regardless of whether your patent application even issues. So by default, patent applications will publish 18 months from their earliest priority date. Also, patent applications definitely publish when they go from being a pending application to an issued granted patent. They publish then as well. So these publications can be used against other people who are trying to patent things. So I'll talk about this later on, but during the examination process, the examiner is going to do a prior art search to determine whether what you have claimed is new and non-obvious over the prior art. And one of the things that they can use against other people who are trying to patent the same thing as you, they can use your patent application that's published, or they can use your issued patent that's published. The examiners can use that as prior art against other people to stop other people from patenting something that is the same or that is similar to what you have. And so again, you get this benefit regardless of whether your application ever issues and you'll get it even if you don't enforce your patents if you have an issued patent. Also, think of patents as sort of like an IP arms race. The best offense is a good defense, in the sense that a good way to ward off other folks who have a patent portfolio is to build a patent portfolio of your own. And the way it works is, both companies realize, hey, there's going to be mutual assured destruction if we sue each other for patent infringement. Instead, why don't we cross-license? Or maybe it's an overture to one company buying another one. So a great way to create that sort of situation is by having a patent portfolio of your own. Okay, so what are the basics of getting a patent? What are the requirements that your invention needs to have? So one, it needs to be patentable subject matter, and part of this, another part of this talk will be folks talking about trademarks and copyrights, and in the real talk, people would have already talked about those things. Patents are going to be something that is not it's not an artistic work, which is the subject of copyright. It's not going to be a brand name or logo or slogan related to specific goods and services, which is the realm of trademarks. Patents are going to cover things that are utilitarian inventions. And so it has to be a utilitarian invention. So if you have a book, hey, that's not going to be patentable. If you have a logo, hey, that's not going to be patentable. That's sort of the baseline of things. Okay. It also has to be adequately described. And this is one of the things that people make a big mistake on, is especially with provisional patent applications, which again, I'll talk about this a bit later on, is they don't have enough detail about how the invention works. They give a really basic description and it's not fully supported. That can be problematic. But really, the main things that it comes down to during the examination process is the examiner determining whether what you have claimed is new and non-obvious over the prior art. I talked about this a bit, but let me sort of break down novelty and non-obviousness. So novelty is there a single piece of prior art that fully describes everything that you have claimed in your invention? And the way this works is, the examiner will do the prior art search and really compare it sort of one-to-one the claims of your patent application with a single, say, issued patent or published pending application. And if you can have all those elements, then it's not novel. Now, usually it's things aren't going to be identical, and so there's going to be some way to differentiate over the prior art. So, novelty rejections a lot of times aren't that difficult. What is typically difficult is going to be the obviousness standard, and that is, would it be obvious to one of ordinary skill in the art, that being your average person who works in the field, to come to your invention based on all known prior art out there? And the way that this works is that you have a bunch of elements in your claims, and the examiner can sort of pull elements from a bunch of different prior art. And assuming they're from analogous fields, the examiner could, pull a bunch of elements from maybe 2, 3, 4 different references and say, well, one single reference doesn't describe that, but there's a piece of it here and here and here. It would be obvious to combine those things and come to your inventions. That is what the obviousness standard is, and that's usually the one that's most difficult when it comes to getting an issued patent. Okay, so when it comes to inventing and developing ideas, there's some really important things you need to understand about patents, and these are probably some of the most important things you'll get out of this talk, and the things that people, the big pitfalls that people, kind of fall prey to. So the first is, you should not make any public disclosures, public uses, or offers for sale before you file a patent application. The reason is because in nearly all foreign jurisdictions outside the United States, you automatically lose patent rights upon a first public disclosure, public use, or offer for sale if you don't file a patent application. In the United States, you have 1 year from a first public disclosure, public use, or offer for sale to file a patent application. Otherwise, you forfeit your rights. But it's important to not use that U.S. grace period. Best practice is to file before any public disclosures, public uses, or offers for sale. The reason is I see this a lot where people say, hey, we're only thinking about the U.S. market, it's not a big deal to us, but then they get involved with certain business partners or investors who have access to foreign markets or are based in foreign markets, and foreign protection is important to them. And I've seen deals be lost because people, intentionally or not, forfeited their foreign patent rights and lost out on a good business relationship or investor. So speaking of investors, that's another trigger to when you should file a patent application. So again, public disclosures, public uses, or offers for sale, or before you're about to approach investors. Now, approaching investors and say doing a pitch or something, typically that's not going to forfeit patent rights, because that's not going to be a public disclosure or a public use, and usually you're not going to actually be offering the product itself for sale. You're going to be offering an investment, which is going to be different. But even if it's not going to forfeit patent rights, it's better to go into a pitch with investors being able to say you're patent pending, and then you can go and be open with them about what the technology is and how it works, because you can go in and say it's patent pending. You have a priority date before when you talk to them. Along with that is, and I hope you already know this, but never go to investors and ask them to sign an NDA. That's going to peg you as, you not knowing what you're doing. They're probably going to be insulted and not want to work with you. Again, the better thing to do is just to file, and typically a provisional patent application at the very least. Be patent pending, go into the pitch and say you're patent pending, and be open with your idea. That's a far better position to be in. And so given that the United States is a first to file system, a lot of people would think, hey, I should actually file immediately when I come up with something. I shouldn't wait until I'm ready to make public disclosures, public uses, or offers for sale or approach investors. I need to file immediately because priority is based on when I file. But the better business decision actually is to wait until, again, public disclosures, public use, or offers for sale, or approaching investors. The reason is because it sort of delays and defers costs. So one, just filing your initial, typically a provisional patent application is going to be, it's not going to be inexpensive. But the provisional application, as I'll discuss later on, only lasts for 1 year. Then you have to file the expensive non-provisional, which is going to be, $10,000, $15,000 just to draft and file that application. And really, you should be getting traction with your business. You should have investors paying for that. Or at the very least, you should know that it's well worth it to spend all that money on that expensive non-provisional application just to draft and file it. That's not even including the examination process, which occurs 1 to 3 years later, which I'll kind of get into later. So again, it's better to wait until you're actually ready to make public disclosures, public use, or offers for sale, or approach investors instead of rushing to file too soon. Another really important thing that a lot of people don't realize, and especially folks who work with copyrights, which are very different than patents, is that investors must affirmatively assign their rights in patent applications to the company. So just being a contractor, just being an employee, does not mean that those folks are required to assign their rights to the company. Okay, and the way that this happens in a negative kind of way is there will be some employees, they come up with stuff, it's patentable, it's the core, the core technology of the business, and then you file a patent application, you go to them and say, hey, here's a patent assignment, can you execute this? And say, well, I'm not required to. There's nothing in my employment agreement that says I have to assign rights, and then there's a big blow up and those employees go elsewhere. Maybe even one employee goes elsewhere. So any employees, who don't have an assignment right, who don't assign, they can fully use the invention, they can license it around your back, and it's one of those things that's going to make your company and its IP kind of radioactive to investors. So in any agreement, whether it's a partnership agreement, collaboration agreement, employment agreement, contract agreement, whatever it is, make sure there are patent assignment clauses in there that assign patent rights from the inventors to the company. That's pretty important. Also, talk with the patent attorney really early. It's good to just sort of get a sense of the lay of the land for your company as far as, hey, when should we file? What's patentable? What's not? What's a good patent strategy for my company? It's usually pretty inexpensive, if not free, to get an initial consultation with an IP attorney. And you're going to save yourself a lot of headache and get a lot of clarity and relief by talking to a patent attorney early. Another thing, and I'll kind of talk about this later, is that ideas and software are totally patentable. Don't think that just because you have something that is software, or if it's just something that is a bare idea, that those things aren't patentable. There's a lot of bad information online about ideas and software not being patentable. Completely untrue. And again, I'll talk about that a bit later on. Okay, so there are two main types of patent applications that are going to be relevant to your product potentially. One is going to be a utility patent application. The other is going to be a design patent application. And it can be a bit confusing because utility patent applications can actually cover the design of something. They can cover systems as in physical things, physical configurations of things, or they can protect methods of doing things. And the example would be, say, a method of using something, a production method, or when it comes to computer technology, it's going to be a computer implemented method of how, say, software works, or a computer readable medium that when executed by a processor executes certain steps. Or a physical computer that that is configured to do X, Y, and Z. That's how you're going to effectively protect software. Again, I'll kind of talk about that later on about why software is patentable. But when it comes to, say, utility patent applications, it's going to protect things a lot more broad than design patent applications do. So designs, they protect one specific ornamental design. There is one drawing of one ornamental design, one physical configuration from a bunch of different views, and that is the one thing that is protected. There may be some little different variations that, may be within the scope of that, but by and large, a design patent covers that one single specific design. It can be really important for certain products or certain specific features of products, but it's not going to be as broad potentially as utility patent applications are. Utility patent applications can broadly cover things with words, so they cover a lot of different variations of things. And so, you can potentially have a lot of variations covered so that regardless of what competitors do to sort of try to change what you're doing, they're still going to be infringing. It's a lot harder to design around. Unlike design applications where, hey, you change the design, a lot of times you're not going to be infringing. Here's some examples of design patents, and they're really, really varied. So it has to be a utilitarian article. It's not, artistic works. These are all utilitarian things. That's the important thing. It's the ornamental design of these utilitarian articles. And so really, from cars to consumer products to keyboards to firearms to parts of vehicles, things like that. Design patents can cover the whole article, or it can cover little specific pieces of it. Okay, and then with utility patents, it really runs the gamut as far as what can be protected. Again, it's going to be things. It's going to be methods, or it's going to be physical things, but it can be mechanical devices, software, web services, web apps, biotechnology, electronics, pharmaceuticals, manufacturing methods, all sorts of things that are utilitarian can be covered with utility patents. All right, so there are two ways to start in the patent process. One is, and I've kind of talked about this before early on, is starting with the non-provisional patent application. This is that really formal patent application that has to have the formal drawings, and if you're doing it right, it's going to be attorney drafted, it's going to be expensive, it has very specific filing requirements, and it needs to have tons of detail in it. So you draft and file this non-provisional patent application. That's the first thing on the first line here that you're seeing. You file this non-provisional patent application, and then it waits in line at the United States Patent and Trademark Office for 1 to 3 years before examination begins. And the only reason why it takes so long, it's the government. You're just waiting in line. You're going from the bottom of the pile to the top of the pile. So after this 1 to 3 years, the examiner is going to pick up the case and is going to do that prior art search and determine whether what you have claimed is new and non-obvious. Now, this is going to start the negotiation of examination, and that's a good way to think about it because rejections are a natural part of it. So think of it like Pawn Stars or American Pickers, where you're haggling over price. So what you're trying to do, again, is you're trying to get the broadest claim scope possible, and the examiner is trying to make sure that what you have is new and non-obvious. So for you to be able to get the broadest claim scope possible, just like getting the best deal when you're haggling with somebody, you kind of have to go back and forth and negotiate. That's a good way to think about the negotiation process. That's how you get the broadest claim scope possible. This can go on, a lot of times it's going to be months, if not years, that this examination process will go on. Again, it's the government, it's really slow. Hopefully you convince the examiner that what you have is new and non-obvious over the prior art. The examiner will allow the case, you pay an issue fee, and then the non-provisional application will issue as a patent. So that is the non-provisional patent application. That's the first row you're seeing. The other option, and this is the one that I typically recommend for startups and early stage companies, is starting the patent process with a provisional patent application. So provisional patent applications, they're just a placeholder. They only last for 1 year and they automatically expire at the end of that year. That term cannot be extended. And that's when you then have to file the non-provisional patent application that claims prior to that provisional application. So you maintain that priority date of the provisional and you get a new priority and second priority date of that non-provisional. Okay, so you start with a provisional, then you file that non-provisional. Provisional applications are great, especially for early stage companies and startups, because for a couple things. One, it's a lot less expensive to draft and file a provisional application. What I'll typically do to keep costs down is work with the inventors to draft an invention disclosure that describes the invention in great detail, scrub that to make sure there's not limiting language and it has enough detail, and we'll file that as a provisional patent application. We don't need to do the full-blown attorney-drafted non-provisional. It doesn't have to have the formal drawings. It just needs to have black and white drawings. And you can still then file that as a provisional. It can be a lot more cost effective, and it's a lot cheaper to get patent pending status and give you a year to test the market, to get investors, to develop the product before you then have to file that expensive non-provisional. Gives you more time to even then develop the product more, and you can add things when you file the non-provisional application. So you can sort of then incrementally protect the invention cost effectively. That's why the provisional is a lot better way to start the patent process for startups. Then the patent process is pretty much the same. You provisional, and then the non-provisional, and then it goes, kind of essentially the same. 1 to 3 years before examination begins, starts this negotiation with the examiner, and hopefully the application is allowed. You pay an issue fee, which then the application will issue as a patent. Okay, so I mentioned software. Can it be patentable? So yes, software absolutely can be patentable, but it can. And let me explain what I mean by that. So you can't literally have claims that say, I patent software. But what you can, you can effectively patent software by protecting a computable, readable medium, that is, say memory, that stores instructions that when executed by a processor performs steps X, Y, and Z. Or you could have claims to a computer method comprising the steps of doing X, Y, and Z, and that would be the algorithm, say, how your software works. Or even a computer system configured to do X, Y, Z. So while you can't literally patent software, you absolutely can effectively patent software just by claiming it in the right way. And what I'll tell you is that's, I would say, 90% of what I do day in, day out is patent software stuff. So I can absolutely tell you that software is patentable. It's just doing it the right way, and that's why, especially for software stuff, it's really critical that you work with a patent attorney to do it. So copyrights can cover software, but they're going to protect one specific set of code. This is going to be good if you're going to have the exact code that's maybe sold or things like that, or the specific code or firmware that's going to be running on a device. But it's really not going to be very powerful protection. Utility patents are going to cover the functionality of software. It's going to cover it at a high level. Whereas again, copyrights only cover one specific implementation of code. And if somebody does the same functionality but just with a different code, that's not going to be protected. Trade secrets can also cover software at early stages, and they kind of go hand in hand with patents, but not not really at the same time. So trade secrets can be good during early development processes, but at some point the patent application is going to either publish when it's pending, or at the very least it's going to publish when it issues a patent. So those trade secrets are going to be lost. So you want to consider when you file a patent application, this is going to become public at some point, and that may be a reason to keep some things a trade secret, things that aren't going to be reverse engineerable, and things that might not be easily discoverable. Okay, so what are some general takeaways from this, and some general tips for startups? So here's like 6 practical tips to protect IP for your startup. And one is, don't use the resources of your current employer to build your startup. That just creates issues where they potentially have an ownership right, or at least with patents, they potentially have a shop right where they may not be able to actually, say, license the technology or things like that, but in a limited way, they may still have some ownership of it. And then with other sorts of IP, especially copyrights, they may own some of that. It just muddies the waters, and a lot of times there's going to be agreements with employers that say, hey, if you do anything with our stuff, you agree to assign your patent rights in that to us, or any sort of IP. So just make sure that you're aware of that when you're developing something. Make sure that it's separate from your current employer if you have one. And make sure you take the right steps to keep trade secrets confidential. So trade secrets only are protectable for things that are where you take reasonable steps to actually keep them secret. So for instance, if you have this secret process, but you let members of the public come into the factory where this is being done, and they see how it's being done, that could erode your ability to protect that as a trade secret. Or if you have windows where people can see in and see how things are done, or obviously if something is reverse engineerable, where somebody could open up a product, they could see what it is, and they could reverse engineer and figure out how it's done. Those sort of things can't be protected as trade secrets. So things like security systems, restricted access to sensitive locations where manufacturing is done, or where trade secrets are held, make sure you have that. And non-disclosure agreements, that's important as well. Any sort of sensitive material, make sure it's covered by a non-disclosure agreement for people who are working with those materials. When it comes to trademarks, be sure to select a distinctive and strong trademark. And this is something that other folks will have talked about early on in this presentation, in the full presentation. But to kind of give you the basics with trademarks, you can have really distinctive marks, things that are, say, arbitrary and fanciful, that are made up words associated with the goods and services. Those are going to be really strong marks. Whereas you can then have this on the spectrum. You can have things that are generic terms. Like if you are selling beer and you want to trademark beer, that's not going to work. That's generic to beer, so you can't trademark that in relation to that. Then there's things that are arbitrary related to the mark. So a good example would be apples, right? So, well, apples, if you are selling apples or apple pie or something, apple is not going to be a strong trademark. It's not going to be distinctive. It is, almost generic to those things. You're going to get no protection. But it depends. Trademarks really depend on the specific goods and services. So again, for apples or apple pie or something, not a very good trademark. But for computers, hey, that's a great trademark, because what do apples have to do with the computers? Essentially nothing. So there's no connection there, that could actually be a distinctive mark. So one thing that, when it comes to trademarks, talk to a trademark attorney early. Do a trademark search, determine how protectable your trademarks are going to be. And a lot of times, early on may be the time to pick better trademarks if what you're trying to do isn't going to be distinctive and isn't going to be very protectable. And part of that is, spend money early to avoid spending big later on. A lot of times it's going to be cheap, if not free, to get an analysis for trademarks, copyrights, trade secrets, and patents. Especially on the patent side, it's not going to be that expensive, or it's probably going to be free to get an initial analysis of things, and it's going to save you a lot of money in the long run. And like I said, with trademarks, you want to do a search to determine, hey, does somebody else have this trademark? Am I going to be able to trademark it at all, given the specific goods and service that I'm using the trademark with? Is there going to be any issues when there's actually the examination of that trademark? And you want to, instead of going off and spending a ton of money on branding and buying domains and all this kind of stuff, work with a trademark attorney, and you can, usually pretty inexpensively do a mark clearance search to determine, if anybody has the mark you have, and also whether it's going to be protectable at all and whether it's going to be distinct enough. Also, do not do handshake deals on things. And this kind of ties into what I was talking about earlier on with inventors. They have to actually assign their rights to the company. So don't just work with people on a handshake deal. Make sure you have some sort of collaboration or employment or contract agreement where there's these IP assignment clauses. So you make sure that the IP that these people come up with actually is assigned to the company. And again, talk to IP counsel early. I hate to sound like a broken record, but yeah, it can be cheap, if not free, to get a lot of really important advice on, on how to protect these things, when to protect these things, what's protectable, what's not, how to prevent you from losing rights, things like that. So talk to IP counsel early. It's going to save you a lot of money in the long run. If you got any value out of this video, please give it a thumbs up. And if you want more content on patents and startups and intellectual property, be sure to hit the subscribe button, hit that little bell icon so you don't miss any great new videos that come out. Here's going to be a couple of, or actually probably over here and here, here's going to be a couple of videos also that are good patent content. So thanks for watching, and we'll see you again in the next video. Thanks.